Good morning to present. I, Niharika Rajpurohit, on behalf of GCC and DSNLU, appreciate your presence for today's session on crime against women and human rights, problems and perspective. Crime against women is not bracket rule. It has taken many forms and is done by different capacities. It has never been a question of age, stature, relationship, proximity, and like. Today, we take an initiative to understand the concerned issue from our guest's viewpoint, to much less make ourselves aware. Committee of DSNLU established with a bona fide ethical mission to spread awareness about gender sensitization in and around Vishakhapatnam. It aims of all the genders pertaining to the society. Gender champions are designated in all educational institutes across the country to promote gender equality and to change the mode of interaction at all levels, such as home, school, colleges, university, workplaces, etc. Our committee is graciously working under the esteemed guidance of Honorable Vice Chancellor Sir, Professor Dr. Surya Prakash, and Honorable Registrar, Professor Dr. C.M. Rao Sir. But all this would not have been happened without the aid and assistance of our Vice Chancellor, Sir, Professor Dr. Surya Prakash, Sir, who joined us in 2018. He had 30 years experience in academic and worked as lecturer. He was also awarded the University Prize V.N. Dekitulu Award for securing highest marks in the branch of labor laws. Later, he was awarded PhD in law from Berhampur University, Odisha. Professor Surya Prakash is a prolific writer and wrote on several contemporary issues. Sir, we are pleased to have you here as our Vice Chancellor. Please take it ahead for an inaugural address.
Okay. Thank you, Niharika. So, at the outset, I welcome all our honorable guests, Honorable Sri Justice T. Rajni Garu, and Honorable Professor of Law, Sri Nirella Ji from Sri Lanka, Colombo University, and my friend Dr. Raka Arya, just joined for this webinar from National Law Institute University, Bhopal. My colleagues, my registrar, Dr. C.M. Rao, Professor Bhavani Prasad Panda, the Professor Emeritus, former Vice Chancellor, Maharashtra National University, Mumbai, who is guiding all the academic events in this university, and Dr. Dayananda Murthy, Director, Research and Academics, and other senior colleagues and teachers, my student friends, and the guests who are participating in this webinar. And I welcome all of you on behalf of DSNLU and also on behalf of myself. And today we have been witnessing the nature of crimes, and we have witnessed the Nirbhaya, and every day the offenses against women, they are on rise, and particularly during this pandemic period, during this lockdown period, and the report says that the number is increased. How to deal with in this patriarchal society, in the male domination society, no doubt. But the attitude is changing, that is bothering. There is the attitude of men towards women. Earlier, it was only what I used to read in the newspapers since my childhood, once in a blue moon, and particularly in AP, in southern states, the offense like rape used to be reported once or twice in a year, hardly. And that itself used to be a very, very big news. But today, it has become a routine in the sense that some, and particularly because of social stigma, many of these offenses against women, they may not be reported. and even if they reported, and it will take a lot of time and live about this pandemic situation and lockdown. Even otherwise also, uh, due to long delays, this gives encouragement in one way. The law won't do anything. So definitely things may be delayed, but law will take its own time. In spite of rigorous laws, and we have changed Section 376, and not only these kind of personal offenses, even gender discrimination at workplace, sexual harassment at workplace, and even the economic scenario where women they are paid lesser than the men, even for the equal work. Even though we have the Equal Pay for Equal Remuneration Act 1976 is there, but grossly it is violated, whether it is domestic workers, and unfortunately, the society looks at certain kinds of employment. Men are more eligible, and women they should be more for academicians and nurses. That is like soft jobs. But thank God to the present scenario in India, even women they are selected and working as fighter pilots. That is the ultimate job in one way, where it requires tenacity, physical, mental toughness, and one of the most toughest jobs. And now, when they are going for combat, taking the combat roles. So, in spite of all the capabilities, well, they are well deserved for many other positions, but still they are discriminated. This is not only a general opinion, but also factually, this is what's happening. And if you make a comparison with the developed nations, and in India, it may be relatively uh, better in keeping in view 130 crore of population. And if you see the percentage of offenses against women, but still that itself is an alarming number when we compare with the 1970s or 60s. And even the education system and the values, slowly the values are the erosion of values in the society. And there are so many factors. So this webinar, if it could, we have the experts, Honorable Justice Rajini Ji, a self-made person who has reached the heights in the judiciary, and he uh, she possesses the judicial mind. Why I'm saying this? In many matters, she's where one has to be sensitive, she was very sensitive, and where one has to be tough, she was very tough in her judicial pronouncements. So, where, for example, in Sheikh Azad versus Union of India, others, so there was a case where uh, the, she has adopted and endorsed the theory of utilitarianism, and in which she observed that the welfare state is one which seeks to ensure maximum happiness to a maximum number of people living within the territory. So she has not only endorsed the Supreme Court opinion, she herself contributed the philosophy of utilitarianism. That means that she has that tender and sensitive soul that in even in our text say that the welfare of all people. And similarly, where one has to be tough. In K.K. Durga Prasad versus State of AP, where a person who has, as per the, he was a government leader, law graduate, and initially appointed as a government leader. After some time, according to the terms of the agreement, he was terminated without assigning any reason. So when the procedure, as per the contract of service, if the procedure is followed, the Honorable Justice Rajni observed that it is not necessary to issue the show cause, that is in the sense that the reasons need not be explained when the termination strictly follows the procedure in the agreement. So similarly, she is very practical. At times, human memory in the anxiety, at times we may ignore certain things, even though if they are most serious at that point of time, but still human memory may fail. So one such case where Muhammad Abdul Rauf Sheikh versus State of AP, here this boy, he attended for Group 1 examinations. And in the Group 1 examinations, there is series A, B, C, D, the question paper, where he has forgotten to mark, to bubble the series. Though he has answered in a much better way, scoring some 135, 140 around, where the cutoff, which is much higher than the cutoff mark, but he was not called for the interview. He was not selected for the interview. So his only mistake error is that he didn't the technical error. So Honorable Justice Rajni, she came to his rescue. Though, and in fact, for such small errors, she has referred another case from Telangana where in the competitive examinations where such technical errors happens, there was a technical committee to look into whether this is a grave error or an error which could be ignored. So the objective of examination is to assess the merit of the student. So one technical error, smallest and very minute technical error, it should not cost his future or the months of hard work which he has put up for preparing for that examination. Should took a very realistic approach and said that as such in AP, in state of Andhra Pradesh, there was no such technical committee, and the boy should be exempted in the sense that technical committee should be, in the interest of justice, deem it fit to direct the respondents to evaluate the paper of the petitioners, that is the boy, with the help of the documents and the data available with the respondents. So merely because of that one small technical glitch, his paper was not evaluated. Though after when once the key is produced, each candidate can calculate how many marks, how many questions he has answered correctly, and what is the probable score he could collect, he could assess. When he assessed that, he scored very high marks. But his paper was not evaluated, he was not invited for interview because of this. So, what I wish to submit is that the judge should work like a horse and live like a hermit. And this is very aptly applicable to Honorable Justice. And there are so many cases where even where one has to protect the human rights. Human rights are meant for human beings. Where one may be a prisoner, or one may be an accused, or one may be a scholar, or one may be in the highest power. And as the Supreme Court, in the logo of the Supreme Court, which says that Eto Dharmasya Tato Jaya. So this is the most appropriate quote, which was taken from one of our great epics, or Itihas. So that Itihas is Ramayana and Mahabharata. And this quote of the Supreme Court, that is, you will find in the logo of the Supreme Court, Eto Dharmasya Tato Jaya. So one will find this quote spoken by a number of times in Mahabharata. One prominent context is that when, before commencement of the battle, Kurukshetra, Duryodhana went to seek the blessings of his mother, Gandhari. So normally when son goes, touches the feet of mother, seek blessings, our usual practice is that, Jeeta raho beta, sabko maar dalo. But she didn't say like that. But she didn't say. Even though Gandhari, she was so affectionate to her son, particularly to Duryodhana, but still she blessed him, saying that, Yato dharma se tato jaya. Where there is dharma, victory shall be to dharma and dharma only. She has no bias because this fellow is my son. She didn't show, she was so objective in giving her blessings. That means one should not look into the status or the capacity or the power, etc., of the subject, that is the petitioners or the respondents before the court. Simply, the court should deal with the matters very objectively, ignoring the persons who are standing before them, irrespective of status and others. So when I read this judgment of K.R. Giribabu versus State of Andhra Pradesh and others, so here is an accused person who was involved in 43 offenses. So going to the prison, going to the police station, going to the jail, coming to the court, it was his routine business. But he could not get bail in some cases because he was already in the custody of the police or in the sun. So we know how the police will apply the law. Law says that any person who was arrested should be produced before the nearest court within 24 hours. So the police are police everywhere, whether it is United States or India or Sri Lanka or Europe. With a little bit difference, the police are police. What they will do, they may arrest at any point of time, but they show that on record he was arrested just 24 hours before producing the court. So this is Rajniji. Here, this fellow, he was denied bail. He could not apply for bail within time. So see the record. See the record. He was involved in 43 offenses. There are 43 cases against this one accused person, and he was denied bail. Then, Madam Rajni's observations. This is so. Who is in custody in different times can be deemed to be in custody pertaining to other crimes. So he was already in custody. It is deemed that he is already in custody for other crimes in which he figured as accused. Therefore, the remedy of bail under section 439 of CRPC cannot be denied on the ground that his arrest was not shown in the crime in which he is shown as accused. So even though he is an accused, even though there are a number of offenses slapped against him or was an accused in so many offenses, but when he deserves, so there can be no reason for the police not to show his arrest in the current crime except the reason alleged by the petitioner. So this is a very objective perception, which is the prerequisite of a judicial mind. And as a justice of the High Court of AP, there is no doubt that Honorable Justice Rajni, in her glorious career, has delivered best judgments, and which reflects her judicial scholarship. And we are very fortunate that to have Honorable Justice Rajni Madam with this webinar. With this, I also invite once again our Honorable Chief Guest Rajni ji and guests of honor Mutkudani Rilaji and Dr. Karya and all my colleagues, and for this wonderful webinar conducted by Dr. Nirmala and Dr. Bhaglashmi, and also to Niharika. I welcome all my students. Thank you, Niharika. Over to Niharika.
Yes. Thank you so much, sir, for giving us a broad insight to the topic. However, no educational instructor of an incredible academic advisor, Professor Dr. Bhavani Prasad Panda, sir, who has always been available for his students and their learning. He is an academic advisor of DSNLU and have been former Vice Chancellor of MNLU, Mumbai. He has academic research and administrative experience for more than 35 years. He is also a recipient of Professor N.R. Madhava Menon Best Law Teacher Award for the year 2016. Sir, we are grateful to have you here. Please take ahead to an introduction to today's webinar.
Niharika, are you able to listen to me? Thank you, Niharika. Yes. It's my privilege to address this particular wonderful webinar being organized by DSNLU. Honorable Mr. Vice Chancellor, Professor Surya Prakash, Honorable Justice Rajni Garu, Professor Nirala, Professor Rakarya, my good friends, Professor C.M. Rao, Registrar of the University, and the organizers of the seminar, particularly the Judge Champion Committee, Dr. Nimla, Dr. Bhagyalakshmi, all of you, very good morning. I'm sure my job is to introduce this particular theme theme of the webinar. Let me tell you very frankly, this is a very important topic and very interesting topic. No doubt, this keeps us occupied for every day, every moment. You open a newspaper, you get situations where you have to think seriously what is happening. I'm not very much optimist. I will start with the words, it's very, very frustrating to see how the things are happening every day and every night. Every day, this particular violence against or crime against women has been shooting up. This is something quite disturbing. And I don't know all the wit, intelligence of the legislators, executive, judiciary put together is still not able to abate this particular rising trend of the crime. I go back to the year 1980s, Mathura rape case in India, and soon after the case, when the rape has been committed by 2 police constables on a Dalit girl, Mathura, and Supreme Court has to acquit because this is not a fit case for the punishment for the reason the rape cannot be established. Somewhere passive submission has been accepted and consent has been read in, so the constables were let free. The question came, there is an open letter to the Chief Justice of India by eminent Professor Upendra Baxi, Lotika Sarkar, and all these wonderful teachers, activists those days. They wrote letters, they say, if the police station is a place of sexual intercourse, and we couldn't do anything, then the Indian legislature started taking up the things into their shoulder. They started bringing a legislation which is called as Criminal Amendment Act. Criminal Amendment Act 1983, Act number 45 of 1983. And when this particular act came into when it was enacted, we thought, yes, now we're in a position to solve all the problems with respect to sexual offences or rape offences in the country. Like the rape was identified with aggravated situations, including custodial rape, and punishment was also increased. Evidence, law of evidence was also tightened. The burden of proof shifts to the accused person the moment the sexual intercourse is established and the consent is denied by the victim. Thereafter, the criminal procedure code also was reframed, making the offences to make this particular victim's identity, etc., public, and there is an in-camera trial. For not many things we made in this particular Criminal Amendment Act. It was one of the high watermark of a rape law that has been designed. We thought that we have solved the problem. But immediately we have identified this particular law did not deter the rapist. And the rape cases started increasing over the years. And unabated, very frustrating, nothing would happen. In the meanwhile, we had also what is called as that particular legislation, Vishaka versus State of Rajasthan, and it was given by Honorable Justice. And this particular judgment has really created at least safe place for the working women. That we thought, and sexual harassment was probably attended, but nothing stopped the sexual offences and the crime against women started still seeing the rocket speeds high, getting up everywhere, every day, statistics, and making the moment you open the newspaper, you feel so frustrated. What is happening? If the police is insensitive, don't know. If the executive is not able to build the things, if the defense is so strong, the prosecution is not able to do anything, or the courts, they have played their own role, and ultimately, were not satisfied. The people in the society were not satisfied with the happenings with respect to women in our society. We couldn't really treat the women And we could not really suppress that particular animal living in probably every human being. That animal remains let loose somewhere, and he only gets a punishment very rarely, because most of the rape cases are not reported. It's a very dark crime. In this particular crime, the dark area is much bigger, the gray area is much bigger. Only very few cases come to limelight, but still nothing could happen. And the matter has gone further. Nirvaya case came. 2013, we have brought this particular legislation once again, and Justice J.S. Goma, and along with his two most efficient colleagues, Professor Advocate Gopal Subramaniam and Leela Seth, and they started taking this particular message to the whole of the country, asking, give us the clues, your views, how we can stop this particular crime. And more than 17,000 questions that they came, and this particular committee has really worked hard and brought out a law. And the definition of rape has been extended. Now it includes, if one studies this particular definition of rape, I think the police investigation has to think something different. Or we need to go that nitty-gritty of the police investigation of a rape victim. Any type of manipulation of the woman body also can be called as rape. To that extent, the rape law has been defined. And in such particular situation, the consent is denied, the accused person can be brought to home. And he has to move. Once the act could be established some way by circumstantial situation, the presumption will automatically have to shift. The accused is to establish with all such particular force. Not only that, look, we thought punishment, severe punishment has a deterrent value, and we have thought of giving bigger punishment, and much bigger punishments are given. Now, nowhere in the history of the Indian Penal Code, 20 years imprisonment, and life means life imprisonment. Rest of the life, natural life. These are the interpretation came in 2018 Act, but still 2020 rape cases will happen. Atrocities are there, and we don't know. And some sordid cases have been. Look, I've been there in many committees earlier in the universities and also other committees of the state. I found this matter is very frustrating. When the offense against women comes, yes, for speaking across this particular webinars, seminars, conferences, it looks something wonderful. We can give suggestions, but when really it comes to us, comes to the person, comes to the student, comes to the daughter, comes to the sister, comes to the wife, comes to the mother of the family, the things are something very different. We suddenly find the whole world is hostile. I'm speaking from the adversarial other side. As if I'm thinking that other person is a woman victim. But the moment I am the victim, I see the whole world becomes hostile. The police doesn't believe me. The judiciary looks in different eyes with their own emotions, with their own background, with their own understanding of knowledge and law, the black letter law. And the question of the victim's situation is still so sordid and so horrible. And this particular webinar probably will try to speak something about how to remove the frustration of the people all across this particular women victims. This is Crime Against Women seminar. The woman is the victim, how this particular woman is feeling, even the slightest manner, how this is being remedied, how it is being considered by the world. So how the world is looking to the woman victim, and it is high time all your criminal justice system has been working hard to make this, to fix the accused person. It's accused oriented, accusatorial. Now something is time for restorative justice. Woman victim, the victim is the most important person. The victim should be taken care of. If we are not bothered what you're doing with a criminal, you punish him, you penalize him, do something. If you are capable, if your police could catch them, if your judges could do that, please do that. I'm not worried about it. I'm a victim. I need to be redeemed. The woman victim is so hardly considered and has a little space, the criminal justice system, whatever the law that has been given as a compensation, or maybe some particular restitution, these things are meager. I want my dignity back, human dignity. And that is the purpose of the webinar. With these particular few things, I wish the great three speakers, Honorable Justice Rajani, Honorable Professor Nirala, and good friend Raka Arya, you are going to deliberate on this thing. We'll be happy to listen all these things. It's not my cup of tea to keep on speaking. I'm here the listener. I'm the taker. I have to remove my frustration. Thank you very much for giving this wonderful opportunity. Madam, it is you who are looking to do. Thank you. Thank you very much.
Yes, Niharika?
Niharika.
Lakshmi, Niharika, please attend.
Niharika.
Yeah, I think probably Niharika's mobile is somewhere.
Okay. It doesn't matter. I will introduce Honorable Justice Rajani
Yeah,
Madam.
that's better.
Yeah.
Thank you, Professor. Thank you, Akshay.
In order to save the time, so there should not be any disruption. Honorable Justice T. Rajani Madam, born on 6th November 1958 at Annama Botlavari Palem, Prakasham district in Andhra Pradesh. Her mother, Srimati Rama Tulsamma and Sri Venkatapaya, parents, and she studied her school and college at Guntur and later joined in Andhra University for law in 1977 and completed law in 1980. So, ma'am, myself, Professor Bhavani Prasad Panda, we are also students of Andhra University. The same teachers, Professor Gupteshwar, Professor Lakshman Rao, they taught us. And we are happy. We are inviting our senior to this webinar. And she got enrolled for law practice in April 1981. And Honorable Justice Rajani Ma'am practiced law in Guntur from 1981 till she was selected as a district judge in August 2002. Ma'am, for a short span of time, I also practiced in the Guntur District Court.
Oh.
So, in the Mufsal Court, Tenali, my senior was Rupakul Ramkrishna, RRK.
Okay.
A very senior person, just only for a short period of time. And later she was elevated as a district judge, selected as district judge in 2002. After 4.5 months training at the Judicial Academy, Justice Rajani, she was posted as second additional district judge at Karimnagar and later worked as first additional district judge at Karimnagar. And ma'am also worked as a judge of the Mahila Court, Hyderabad. So she was aware of the problems and offences against women, no doubt. And she also worked in the as judge of Economic Offences Court, Hyderabad, and district judge Medak and Metropolitan Sessions Judge, Hyderabad. And ma'am was elevated to the High Court of Andhra Pradesh in the year on 17th January 2017. And since then, she has been rendering in the service of justice to the people of Andhra Pradesh. And I have given few remarkable judgments. There are a number of judgments delivered by Honorable Justice Rajani. Just to amplify her judicial mind and her judicial scholarship, I have given a few instances of different shades of justice in which she delivered the pronouncements of the judgments. So with these few words, ma'am, we are very honored to have you as chief guest for this webinar. And I request on behalf of DSNLU and my colleagues and my students to invite you to deliver your talk on this webinar, ma'am. Thank you, one and all.
Thank you, sir. Thank you. Due to internet glitches, I am unable to connect, sir. Ma'am, welcome, ma'am.
I introduce no issue.
In fact, I should thank Honorable
Vice Chancellor of DSNLU, Professor Dr. Surya Prakash, for double introduction, not one introduction. I'm happy to be here. The Vice Chancellor, DSNLU, Professor Dr. Surya Prakash Garu, Professor Bhavani Prasad Pandey, Professor Nirella, Dr. Raka Arya, Professor CM Rao, and all the participants of the webinar. A very good morning to all. It is with deep pleasure that I'm here to participate in this webinar. I hope the webinar would find solution for the problem that it seeks to address. In the course of my speech, I may be differing with certain things which are said by the earlier speakers, particularly Professor Bhavani Prasad Pandey. Anyway, the organizers titled the topic for the seminar as Crimes Against Women and Human Rights. To me, it appears to be encompassing many aspects and posing various questions. The intention might be whether crime against women is violation of human rights,
Yes.
or whether women rights are human rights, or whether protection of human rights has a nexus with crime against women. I'll start addressing the first two aspects, continued by the third one too. It is really deplorable and pitiable that the question whether women's rights are human rights still lingers around after 70 years of our constitution, which has a preamble with equality, liberty, and justice, apart from fraternity as its constituents. Any unequal treatment of a citizen is violation of the constitutional mandates. Women are citizens of the country too. Every human being is entitled for equality. It is thus equality is a human right and also a women's right. Hence, violation of this right for equality of a woman nevertheless is a violation of a human right. Equality between men and women has been among the most fundamental guarantees of human rights. The Charter of the United Nations, adopted in 1945, sets out as one of its goals to affirm faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women. Furthermore, Article 1 of the Charter stipulates that one of the purposes of the United Nations is to promote respect for human rights and fundamental freedoms without distinction to race, sex, language, or religion. Article 13 repeats the prohibition of discrimination on sex. India is a charter member of the United Nations. The Universal Declaration of Human Rights was adopted in 1948, which proclaimed the equal entitlement of women and men to the rights contained in it without distinction of sex. It is interesting to note that there was a considerable discussion about the use of the term all men rather than a gender neutral term, and eventually the term all human beings was adopted, leaving no doubt that the Universal Declaration is intended for both men and women alike. In 1967, United Nations member states adopted the Declaration of Elimination of Discrimination against Women, which states that discrimination against women is an offense against human dignity and calls on states to abolish existing laws, customs, regulations, and practices which are discriminating against women. The preamble of the Convention on Elimination of All Forms of Discrimination against Women, which was adopted by the General Assembly in 1979, explained that despite the existence of other instruments, women still did not enjoy equal rights with men. The convention articulated the nature and meaning of sex-based discrimination and lays on states obligations to eliminate discrimination and achieve substantial equality. It is interesting to note that the convention articulated state obligations to address not only discriminating laws, but also practices and customs. How far have states traveled in fulfilling those obligations is what needs to be introspected by none other than the states themselves. I propose to examine how even women are giving themselves to discrimination unknowingly and unconsciously. India is a multi-religion society with separate strictures, and holy books for each religion. Women of each religion who believe in it proclaim their faith to the scriptures also. They accept the sanctions of the religion unquestioningly. They feel obligated not to point out the inequalities that are depicted in the scriptures. Every religion treats women as inferior to men. We have to accept that. Draupadi is an article of pledge in Mahabharata. Character test is only for Sita in Ramayana. Bible lays down a prescription for a woman who delivers a child to stay away for a certain period as being unholy, which unfortunately is double in case of a delivery of a female child. To what sense of rationality do these prescriptions appeal? We know the status of Muslim women, practice of talaq, parda, etc., which are meant only for women. These practices do not clash with gender equality, but they perpetuate discrimination and clash with universal rights to non-discrimination. We too have religious anti-rights people which work to curtail human rights protection. We have conservative mindsets fighting against emancipation from customary practices. I remember the uproar against one judgment rendered by the Andhra High Court in the year 1982 or 83 by Justice P.A. Chowdhury. You all must be knowing about that. It was in a case under Section 9 of the Hindu Marriage Act, popularly known as Sarita's case. Section 9 provides for restitution of conjugal rights to both the spouses who evidently are unequal, though not in any aspect, in physical construction at least. The judge struck down Section 9 as being unconstitutional, since it cannot be applied equally to unequal spouses. I was astonished, as much as the judge was, by the response and reaction of the society, which included some of my so-called good friends, who till then gave me an impression that they were in support of my independent thoughts as a woman. This all comes from acceptance of the stereotype assimilated by the religious scriptures, which are accepted due to merely being religious prescriptions. Even a woman who suffers does not develop an inclination to fight against the inferior position given to her in the religious scriptures. They bear allegiance to all these prescriptions since they are sanctions of religion. There can be no problem in accepting these scriptures as historical texts. The trouble is with accepting them as religious scriptures. We fear to question them, to violate those prescriptions, and to fight against them, even if we see that something is wrong with them, because as I said, it has religious sanctions. We are witnessing those societies which accept that women are necessary for the development, their contribution to the society is imminent for the progress of the society, are progressing. The need to protect human rights is to ensure that people have basic needs met. Everyone needs access to medicine, food and water, clothes and shelter. They are basic rights which belong to everyone equally, regardless of gender, sex, age, sexual orientation, or any other status. When we talk about human rights, which deal with crimes against women, we mainly go with the thought that violence against women is a violence of human rights. There can be no second opinion about that. But a little deeper probe alone would find an answer and give a solution to crime against women. I have somewhere read that human rights protect vulnerable groups from abuse. But in a society which upholds and protects the human rights of its members, there would not be any vulnerable sections left at all. If ensuring basic needs would mean upholding human rights, that is the first step that is to be taken by the organs of the state who have the responsibility towards the society. Human rights protect vulnerable groups. They allow people to stand up to societal corruption. They encourage freedom of speech and expression. They give people freedom to practice their religion. They allow people to love who they choose. They encourage equal work opportunities. They give access to education. They protect environment. They promote a universal standard that holds governments accountable. But who are to protect these human rights? Can individuals do that for themselves? If the answer could be yes, there need not be any debate on human rights. We have a mechanism in the form of electorate to elect people to the position where they take the responsibility of ensuring all the above to the people who elect them. People vest enormous power in them in order to take care of the society. They have nothing less than an ideal society in their minds while electing them. It is for the people occupying positions in those institutions to realize our dreams for us. Whenever a crime takes place, we think from the point of view of a victim. We also have human rights organizations fighting for the rights of prisoners while in prison. This is where I would like to differ with Professor Pandey. There are organizations who fight for good food, hygiene, and basic amenities to the prisoners once they are inside the prisons. But we, at least I did not see those many voices raised for these provisions to the people who have the potential of becoming criminals and prisoners due to lack of all these. If the magnitude of these voices grow in that direction, crime would be totally eradicated, not crime against women alone. We have seen such societies exist. We, as part of society, do not pay attention to the growing potential in a person to turn into a criminal. Nipping a criminal at bud stage is easier. The money and budgets that we spend on force to protect women from violence, for rehabilitation of women, for conducting seminars on crime against women, for punishing criminals, for maintaining jails, for establishing special courts and recruiting judges to try those cases is enormous, the budget. Instead, if the budget allocation is made for education, for health and hygiene, for basic amenities like food, shelter, and clothing, it would address all these issues. So long as the society retains its capacity to breed criminals by being indifferent to the needs of the people, there would be no end to crimes and crimes against women. You should accept that I'm frankly speaking from my heart, because this keeps boggling my mind all the time when I go on roads. Punishing a criminal is not at all a solution in my earnest opinion. The deterrence has proved to be a failure in Indian society. Society should travel towards upholding the fundamental rights and freedoms of every human being, when automatically rights of women would also be protected. Let us pay as much attention as we are paying towards crimes and victims, towards the criminals, their lives, their conditions of living, the way they are growing, the sensitivity and sensibilities that need to be given to them, which is possible only by being sensitive towards them. Let there be seminars on the reasons for crime rather than punishments to criminals, because deterrence, as I already said, is a failure in our society. That would be a real tribute. Holding seminars addressing these issues would be a real tribute to Article 1 of the Charter of the United Nations, which prescribes respect for human rights and fundamental freedoms. Let us all be agitated about the violation of the human rights of a neglected child. A neglected child is deprived of all opportunities of growing healthy, both physically and mentally. His experiences are of neglect, denial, and deprivation. Let us develop awareness within ourselves that a neglected child is a future potential criminal. Let us work for realization of the children's rights: right to live, right to work, right to education, right for love and concern, right for health and hygiene. Let us strive for a society which leaves no neglected child. Such society would be free from all kinds of discrimination and all kinds of violence. By education, let me tell you that I mean education which resolves the conflicts in the child's mind and not the one which creates conflicts. Education which teaches human values and nurtures to respect the human rights. A person who is not educated thus is also a neglected person. be he a neglected child by the family or not, he remains to be a child neglected by the society. Let me end up with all-time slogan, let us respect the human rights of child, and then the human rights of each individual, including women, would be protected. So this is what basically I wanted to present before this webinar. I was given, I think 40 minutes time, but I wanted to contribute some of my time to the interactive session so that it will be more fruitful. So I'll join the interactive session and I think we can discuss better. I throw my thoughts for the participants of the webinar for discussion. Thank you. Thank you very much.
I apologize for the technical problem. And with the opportunity of webinar, I think technical glitches are the hardships. So I apologize for that. But to move ahead, thank you so much, ma'am, for giving us an insightful and that is the criminal behavior, and that it starts right from the beginning when a person is born, and for also giving us a solution in the form take the webinar and our next guest, Professor MAD SJS Narila ma'am, who is hailing from Department of Public and International Law at University of Colombo, Sri Lanka. Madam has started her career as a faculty of law, University of Colombo in 1993. Since then, she held several administrative positions at university level, including the head of department, deputy director, examination virtual campus, University of Colombo, member of board of management of Postgraduate Institute of English, Open University Sri Lanka, and nominee for the selection committee of University Grand Commission Sri Lanka. She has held important national positions in the country. She has published books with reputed publishers such as LexisNexis, India, Springer, Emerald, David and Company, Medgrave, and a few with local publishers. Professor Jiva Nirala is a well-respected academician in the fields of law, human rights, criminal justice, criminology, and victimology, which allowed her to undertake positions in international associations and societies. She is a member of Executive Committee and the Constitutional Center for Women's Studies, the Presidium of General Assembly of Asian Criminology Society, as the first Sri Lankan who has been appointed to the board for the period from 2019 to 2021. She is the first Sri Lankan Vice President, South Asian Society of Criminology and Victimology, and the first female from South Asia and first Sri Lankan member of the Board of Directors of International Society of Criminology from 2019 to 2024. Madam includes her pioneering several important academic initiatives as well. She introduced criminal justice as a subject at the postgraduate level in University of Colombo in 2008 and the Open University in 2009 for the first time in the academic history of the university system in Sri Lanka. She has introduced the certificate course in Fundamentals of Criminal Law for non-lawyers in 2019. She received the title National Honor Award confirmed by the Democratic Socialist Republic of Sri Lanka at the Ceremony of National Honors 2019. This is an award conferred to recognize distinguished service of national meritorious nature to the nation. She received other research awards as well, such as the Best Presentation Award for the paper titled Sri Lankan Contribution to Peace and Security in the World, and would really be gracious to have your viewpoint. Thank you.
Can you listen to me?
Yes, ma'am.
Right. Good morning, everyone. I'm little embarrassed. I mean, the long introduction given of me. I think it is you have copied from the university profile, right? I think everybody we have to write in order to give the pride to our university. So it is not because anything to to market myself, but the university expects from us to write that. More to that, I would like to say that I'm the mother of two children. So that is what the best introduction that anybody can give to me. I'm an Asian woman. So I like if anybody introduce me in that way, because I mean, not like the western part of the country, the Asian women, I think we are proud of that, some of the values that we really respect. But on the other hand, relatively than the Western culture or the Western countries, so-called the developed countries. So we are the South Asian countries. We are having one of the biggest problems that the violence against women, or that in other words, the women, the crime against women. That is why we are here to discuss about that, to consider and a webinar to enlighten all the students and whoever willing to participate in this webinar, to know about, the reasons for committing crimes against women, what are the consequences, and what is the, the special reference to Indian law, since you are this webinar, the criminal justice system, what is their role, and what the society can do in order to prevent violence against women, or rather the crime against women. And therefore, we have very eminent speakers, Professor Raya and Justice Madam, and two eminent professors also in giving introduction and all. So I'm so happy, and I consider that as an honor to me to be a panelist of this conference today. So I would like to greet everybody, saying good morning, namaste, and aiboan to everyone. Again, I want to thank Professor Surya Prakash, the Vice Chancellor, sir, of this prestigious university, giving me the opportunity and inviting some to contribute to some other in other aspects as well, be a committee member of your research, the committee and all. So then I highly appreciate and respect that. And I would like to, having said that, I would like to say that my topic for me is women, women victims of crime, international human rights perspective. So I thought that when I saw this, the topic, it was a little bit puzzling to me how to start and formulate what to say, because it is a little bit the broader the topic. Anyway, I try to simplify as much as possible, to enlighten you, to make especially the students understand what I'm trying to say with you, share my whatever the experience, the knowledge I gain doing some of the research and all. So I like to discuss with you in this the 25 the 30 minutes given to you, the next the 30 minutes, then the crime against women and how the international treaty law look into this issue, and what sort of measures and mechanisms have been taken by the international community in order to prevent, one hand, committing crimes against women, and then what kind of the procedure and the practices have been adopted in order to, urge the countries who are being member to these the international treaties in order to, protect women who have been victimized by crimes. And then thereafter, I would like to just, in order to, give a sort of idea of that, I want to just discuss about the prevalence of crime against women and the consequences and some of the reasons for that. So this is all about my presentation. Now, if I would, when I my presentation, I would like to say that, the global population, we are about to, according to as of 1st January 2020, we were about to 8.75 billion of people, and out of that, 50% 4 is male and the 49% 6 is male. I got this all from, population statistics. So it the ratio, man and woman, I'm not going to talk about the 13 and all. Man and woman ratio is 1 to 0.81. So, however, that is, the difference is very slight. But when it comes to Sri Lanka, if you go through the statistics of the population, you can see that the women population is little bit ahead than men. It is 50%, 0.1 of the percentage is women. So, however, now, I mean, from long before, since, even that I entered as the university students, we were talking about violence against women, crimes against women, the women discrimination, and so on and so forth. Today we are, I mean, in the 21st century, the same thing again and again repeating. So therefore, in addition to that, what I'm trying to talk about you, the international, the international perspective in relation to the particular subject, I think that we have to consider, some of the attitudinal change, unless, I mean, we are unable to, successfully focus and find some solution for this particular the issue. Now, however, I mean, you can see that though that we have in everywhere we are talking about, yes, we have to respect women, we have to, consider the rights of the women, so it should be considered as human rights. However, you can see that the crime committed against women, it rapidly and very this in a steady way it is going up. If you go through the global crime statistics, you can see that. Therefore, I think I'm not wrong to say that the women are more vulnerable than some of the offenses we are concerned. They are rape, because according to the definition given in rape in Sri Lanka as well as India, it is not gender neutral, it is gender specific, and marital rape, incest, forced marriage. I think that India has this problem, and female genital mutilation. I don't know whether India has a problem like that. Maybe sometimes yeah, you have the communities who are having a different fraction of the religion, so they might have. But when you go to the Gulf region, you can see that how these women are really suppressing and facing this particular issue. So then human trafficking, Sri Lanka and India are also very famous for that, I suppose. And of course, the prostitution rings and bride kidnappings and honor killings, once again the Gulf region and the Latin American area and the South Africa really, very common the issue of honor killing that you can see, especially against women. Therefore, if you go through the prevalence, right? So I got it from the global the crime statistics. You can see that the 35% of women in worldwide have experienced either a physical or sexual the partner violence, including the legal spouse, as well as the person who we call that cohabitation. But when it comes to the Western world, it is not like that. It's a kind of a relationship. Anyway, partner violence, we can say that intimate partner violence. So then the 35%. Then we take the global the percentage. I say that 49%, 6 something. We have the women the population. Out of that, the 7% have sexually assaulted, maybe either from their the partners or the unknown people. So then the 38% murder, all the other the offenses against body were committed against women. So 200 million women experience female genital mutilation or cutting, this relating to that particular the offense. Therefore, I just want to make aware of you that this is the situation, the worldwide when it comes to crime or just say the violence. I'm literally not touched so far the difference between the two terminologies. So then this is the situation against women. So if you just go to that, so it is said that in 1 in 3 women always they experiences any sort of violence. Particularly from the male partners or even male. So if you take that 29% aid from the Latin American side, that women are facing this any type of the violence or the crime when it comes to our region, that is South Asia, 37.7. So then if anybody can go through that under the statistics of the global crime statistics, so then you can see that how the women are discriminated, and their rights, the basic rights have been violated by committing crimes against them. So let us look at that. That's the second point in my presentation. Look at that, the reasons for committing crime against women. So then, as many of here, even the judges and the Professor Rice with us from Bhopal University, and Professor the Vice Chancellor sir and all, they are some sort of, they are the knowledge in criminal law. They would agree with me if I say that there are so many the criminological theories and the victimological theories are there to consider the reasons for committing crimes. But I'm not going to consider those things in depth, but taking everything together, I would like to say that some of the reasons which are maybe the criminological side, the perspective, or the victimology perspective, you can say that the low levels of education, right? The history of exposure of child maltreatment and witnesses of family violence, association of personality disorder, harmful use of alcohol, having multiple partners, right? It's one of the very common issue in everywhere. And the attitudes relating to the gender differences and to consider women, and the patriarchal, the dominant idea that many people have especially in South Asian region, unlike the Western world, and the community norms which provides the privilege to the men than putting the women in the secondary situation. In some communities, I think that they are evident to consider women like that, and women consider as object of for the sexual desire. Always they are, whether they like it or not, they have to surrender for when the man needs to satisfy the sexual the necessity with her, his the legal partner, or that the intimate partner. And the low levels of victim access to paid employment. So these are some of the common the reasons today we can see that the push factors to commit the crimes against women. In addition to that, there are some other the marital disorder and the dissatisfaction of men. I'm sorry to say, it is not discrimination, discriminating the good gentleman, but it is there. Still, the difficulties in communicating between the partners, and male controlling once again behavior towards the partners. This, and then the weak legal and the criminal justice process, which is provide the access to justice. Then thereafter, all the practice, and finally until the putting the person into jail, plus the less attention given to the victim of the crime, actually what they really need, how they have to be assisted, and what sort of support that we can give to them. So these are some of the reasons for that. So then, having all the the consequences, we can divide into the social, the cultural, the political, and the personal. So then women have to face a lot of the issues because of this the gender-based the crimes, this gender-specific crimes. So therefore, given now I'm engaging the core of my today's presentation, that is the international human rights law perspective. Now, this is the third, but prior to the last and the core component of my presentation. So, my dear friends and the distinguished members in this webinar, as far as the emergence of women's rights as human rights is concerned, women's rights actually initially, received very little emphasis at the United Nations. Though the UDHR, it is very specifically focused on what are the basic rights of the people or the human beings. It did not give the specific highlight or the specific focus on what are the rights of women, but I would respect that some of the articles which you discusses the gender neutral base in everyone, talking the people as the human beings. So, however, whatever said and done, as a woman, I really look at that. So, because of the different needs, the way that we are thinking and all, so then some sort of the emphasis should be given to the women when it comes to crime, or that pertaining to their rights as well, because of the necessity, because that the mother is the person who gives the birth to a child, so the specific needs are there. So suppose what would happen if that the person who is under that condition is being raped. So Sri Lanka, long before 28 years back, we had some issues. So that is why the reason, like in India, in 1984, Sri Lanka 1995, we had the specific the penal legislation in order to consider women and children, especially against the sexual offenses. Even that when we consider the ICCPR and ESHR, so these two are the two subordinate. We say that, the two daughters of the children of the UDHR. So they are also, did not specifically focus on, to my understanding, about this, the women. However, you see that it has the most, the important, the particular, the treaty we call CEDAW Convention, Convention on Elimination of All Forms of Discrimination Against Women. That was the first time articulated the rights of the women as human rights in detail. That is in 1979. That has been touched by the previous learned the judge madam as well. So, however, there are also, once again, what I see that it was not particularly focused on, crime against women. That means, what type of acts that can be considered as the crime. So it is then, however, in 1992, the General Recommendation 19 gave the detailed consideration of the problem of violence against women. There it highlighted the gender-based violence as a form of discrimination that seriously restrain women's ability to enjoy rights and freedoms of equal basis of man. So there you can see that according to the definition, I'm not going to read that the definition, how it has been explained, violence. So then it all listed all the crimes which are considered in the different jurisdictions, more or less. Offenses against body, offenses against the property, all these things are more or less included. There are one particular aspect I want to draw your attention, that is the violence actually considered under physical violence, then the psychological violence, the cultural violence, then as well as the sexual violence that can be committed by an individual, the family, as well as the state also. So there you can see the slight difference between the violence and the crime, because the traditional meaning for the crime is something happen against the state. However, as the previous, the learned speaker that, I'm sorry, I can't remember the name, the second speaker, the Honorable Professor Bhavani Prasad Pandey, sir, he said that the concept of restorative justice, because when it comes to the traditional way given to the crime, we considered only that, the punitive aspect, the rehabilitative aspect, not the preventive aspect, but not the restorative justice aspect. So therefore, if you, how that other than that, the slight difference between the violence when it comes to that can be committed against a woman even by the state, but crime is slightly different. However, it is, the crime and the violence are these two terminologies are interchangeable, and often you can see that consider that the similar way. So then, even that the CEDAW Convention talks about the human rights, the gender discrimination, and taking the best norm, discrimination, but it did not consider that, if something happened, what is the practice should be adopted by the justice system and all. So there is one of the lacking part, I see. So then, there are some other the steps have been taken by the international community to consider having some conferences, the declarations to consider about the violence against women. Rather, we can use that even the crime against women. Right. So then, to me, actually, 1993, the World Conference on Human Rights in Vienna, that was, very important because the Vienna Declaration of Elimination of Violence Against Women. This is the first time, once again, talking about how that we have to look at the violence which can be happen against women. There it talks about the political, the civil, the economic, the social, and the cultural life of the national, the regional, and the international level that can be happen against women, and they can be considered as the violence against women. It specifically focused on the physical, the sexual, the psychological violence can be happen in the family. We call the domestic violence. Sri Lanka, of course, it is not a crime. I would like to mention that it is a civil type of thing, but it given the only the protection the protection order, but it follows the whole the criminal justice, the process. It should go to the magistrate court, then it heard before the magistrate, and the police involvement. All these things are there. So then it includes some of the, all the crimes which are generally considered under the penal code, once again, as the violence against women. So then this declaration further outlines that the steps that that can be taken by the states and the United Nations, right, addressing the gender-based violence against women. And it says that in order to prevent those type of activities, it urges that is the important point, to not to invoke any custom, any tradition, or any religious consideration to avoid their obligation in this regard. Therefore, it touches the first time the differences of the customs, the name of the religion. I think that how women are put into the very the uneasy situation, violating their rights. Further to that, really the violence are committed against them, which we can consider as the crime. So when it comes to the 1990, again, that the UN General Assembly resolution had the focus on the domestic violence. It considered that where you can find that all the listed the crimes, when it happens, the domestic fear, so it should be considered differently, but to provide the protection for the women concerns who are, the subjected to violence at the home sphere. So then 1994, the Commission on Human Rights created the first gender-specific human rights mechanism and appointed Professor Radhika Kumaraswamy from my country, I am proud to say, as the first special rapporteur on the violence against women. And her mandate, even that, not to just to submit the reports on what is happening and going on, but to have some sort of the measures to eliminate this the violence happening against women. Now, the 1995, after that, the Beijing Platform for Action Plan considered against violence against women is the next milestone to me, which is take as the step from the UN community or that the international community to protect the women against crime. There it discusses that the 12 critical areas which are really concerned relating to, the gender differences, the gender inequality, and one particular aspect is the violence against women. Today, I would like to focus that on a term that is the crime against women. Therefore, it says that the systematic rape, the sexual slavery, forced pregnancy, forced sterilization, forced abortion, the forced use of contraceptive should be, prohibited in the any jurisdiction who are member or that being member the signatory to particular action plan. So then the only issue is there, it is not a convention but just a guidance or the declaration. So then that is for the normal situation. Even the wartime, so I think that it is not necessary to say that women are the most vulnerable group other than the women and the disabled people. So they are under Rwanda, the ad hoc, the criminal tribunal. That was the very first time it is, considered that under offenses against humanity, how that the women were systematically raped again and again. That rape, it was considered under genocide as well as offense against humanity. Then more to that, during the wartime, you all are aware that we have the ICC statute, we call that the Rome Statute, section Article 7 and 8, once again consider really under offenses against humanity and the war crimes, the rape, where that the women are systematically put it into the situation where they are vulnerable, specifically crime committed against them. So, when it comes to, here you then see that there are some the international conventions really talk about how to define the particular the violence against women. But in addition to that, there is another specific one you can see that is the United Nations Convention Against Transnational Organized Crime. The first protocol, it talks about prevent, suppress, and punish trafficking in persons, especially women and children. So, which was ratified in 2003. I think you can see that our countries are, sending countries, women and children, or particularly to the so-called the developed countries. So, however, that so these are some of the aspects that I want to look at in relation to the conceptualization of this particular the term, that means the crime against women or that the violence against women. So look into, in a very the 5 minutes time, I would like to focus on the attention. What are are there any practices, the criminal justice system that is, considered to the global perspective or the international perspective? So that the international treaties are soft law. We always, the respect the state sovereignty. Therefore, the international convention cannot be, the international law cannot be incorporated directly into the domestic level. It has been translated into the domestic level through the enabling statute. I think that India and Sri Lanka, we are having the particular the ideology. But when I invite you all to go through the Singarasa case, it is very important case where I always consider that, very correctly the Supreme Court in Sri Lanka pointed out. But however, when it comes to the violation of human rights, so then really necessary to have the enabling statute. But it is, being as a member of that country, so then the state should take the steps to either, prevent or to give some sort of the remedial, the mechanism to protect the victims of crime. So there are, I think, through the one of the, other than the Rome Statutes, even the Rome Statutes, what I see that there is no any the investigation or the law enforcement mechanism if something happen, a crime happens, to take the person to fix the person, the person to the court, and other than the command responsibility. It is not specifically focused on women, but it is, the general situation. So when it comes to as the final point, when it comes to how that we have to focus on if something happen, whether the international the conventions have focus on that. Yes. So if you go through the Declaration of Protection of the crime victims and abuse of power, it talks about the access to justice, the restitution, the compensation, assistance and support to the victim. But there again, what I see is there is no gender differences, but it considers very in a particular way. So the last the point is, whatever we are said and done, whatever we are talking about, right? So the law alone cannot prevent, even the protect once victimized by criminally victimized by any of the women in the country. Therefore, unless all the male, as one of the former presenters said, unless the male people, right, they consider women as their mother, right, then and their friend and wife, who always give all things to the family. Because if mother doesn't give the birth, I know that there are so many other new things are there to give the birth to a child, but the traditional, the natural way is the mother. So if you consider her as a mother, I think that that is one day actually 50% of the problem can be reduced. If not every day, in every year, we have to talk the same thing, but no results can be gained. So then having given this the simple message to everyone, and urge to enlighten this one to your children, the home, practice that to then to give her relief, to and enjoy her to all the given the guaranteed rights in the different the constitutions as well as the international conventions as well. Thank you very much. Once again, I would like to extend my gratitude giving me this opportunity to be a panelist among all the great the panelists. Thank you very much.
Thank you so much, ma'am, to enlighten us on international crime, family violence, and also some less known crimes against women with an empathetic and rational and neutral cursor to genders. Thank you, ma'am, for making this session an easy comprehension from your presentation. We are so thankful to learn from you. Lastly, I welcome our prominent guest, Professor Dr. Raka Arya Ma'am, who is an assistant professor of political science at National Law University, Bhopal, and placement coordinator. She is an alumna and got her PhD in international studies from university. She is also a board member of Transparency International and a member of International Jurist Association, where she has organized several lectures, panel discussions, and conferences. She has an academic experience of 17 years and another 11 years of experience at Vasant College for Women, Varanasi. Ma'am, I welcome you on behalf of university and GCC to put your words forward. Thank you.
Harika, thank you so much. And on the onset, I would like to thank Surya sir for considering me to be a panelist in this galaxy of distinguished speakers and scholars. And I have been given an opportunity to speak on the issue of human rights of women victims in sexual offenses. So I would like to, of course, put some of my views across. Though I know that some of the things have already been said when one is last speaker. So I would like to do justice to my views that has to be presented to all of you. Now, in the beginning, because I have been given the theme as far as human rights of women victims in sexual offenses is concerned, I would like to quote Mahatma Gandhi in the very beginning. He has said that to call women the weaker sex is a libel. It is man's injustice to woman. If by strength is meant brute strength, then indeed is women less brute than man. If by strength is meant moral power, then woman is immeasurably man's superior. Without her, man could not be. If non-violence is the law of our being, the future is with women. I think this particular exposition made by Mahatma Gandhi is speaking volumes. Whatever we are trying to discuss in our interaction today and this webinar, I think we are just trying to understand only this point. Because understanding of women as a weaker sex, it means we are speaking about a society which is based on power relationship. It means we are not talking about two equals who are complementary for each other's existence. Instead, we perhaps treating each other as rival, as adversary. Because power means that subordination and domination. This is the language of the power. So if we think that a society which is being created on this particular argument and logic, then perhaps this relationship will always remain a lopsided relationship. But if it is being considered as two equal human beings, then perhaps all the things that we are trying to discuss here, the prevention, the deterrence, the restorative justice, and all that, I think everything will fall in place. So, what we have to take, because what I would like to say at the end, I have said in the beginning, that this is something that if it is the underlying idea of the social life, social behavior, then perhaps we are courting trouble. And that's why we are saying that I would like to once again say that if they say, if non-violence is the law of our being, the future is with women. So we are constantly understanding like this notion of domination, subordination, which is resulting into a kind of violence inflicted by man on women. So is this a kind of society we have thought about? Is this a society we are discussing about or the philosophers have thought about? So we are just trying to understand number of points here as far as the whole aspect of formation of laws, systems, every single thing is concerned. Now we are discussing about the human right part. If I try to say few things about human rights, because already I think you will be aware of what human right is. Human right is being human. The person who is human, of course, is the one bearer of human right. They have been endowed by nature to all of us because we all happen to be human. They are moral right. Now, moral right means we all do understand, because they are falling in the category of that. We do understand it means enforceability part is missing because state is not recognizing, acknowledging them as right. Because we know that when state acknowledges something, then state takes the responsibility to protect that. It means that it seems that when we are talking about human right, it is more of social responsibility than the state's responsibility. Now, again, we are exploring another question here, that who is a human? Because if we are saying, as I just said in the beginning, that if we are trying to say that the human woman is not being treated as a human, then of course the kind of offenses which are happening against women are very normal to happen. Because if she has not been reckoned with as an existence of a human, she will be subject to all kind of violations. So this is what we have to understand here. The social milieu, the society, the social fabric, what we all have as far as these things are concerned. We are saying that as far as understanding women are concerned and their status in society is concerned, they are different, they have different rights as far as men are concerned. They might be bearer of two types of rights, in the sense that they will be, of course, having the rights that men will be enjoying, but being female, they will be also subject to some different kind of rights, because they are having some reproductive rights also, in the sense they are going to give birth. So they will be given some pregnancy aspect and maternity leave aspect. All these will come into the consideration as far as women are concerned. So we are saying that as far as female rights are concerned, they are slightly different as far as the understanding of men's rights are concerned. We cannot actually try to club them together. Again, we are saying that as far as I think Madam has also said rightly, Professor Nirela, that they are being treated as a sex object. Many a time we do understand that though we say that we are a civilized society, but perhaps I think things have ended there only by in the claim only when we are saying that we are a civilized society, but our behavior is not actually saying that we are a civilized society. Why I'm saying so? Because whenever, a woman has been treated as a secondary member of the society, she will be subject to the kind of ill treatment that she's being. Like I will tell you that the woman has been treated as a symbol of, honor of the family. Now, this is something I may say that as Beauvoir, you might have all heard about Simone de Beauvoir. She was the one who has raised this question of self and other. And she said that man treats itself to be self and woman as other. The whole trouble starts from this interpretation. When we are saying that if man is treating itself to be the core of the society and everything is revolving around it, the problem will start. It is exactly what is happening. Now we are saying that whenever there is a dispute between man, families, communities, nations, then we see that women do become victim of the violence inflicted on them. To settle a score with man, generally people do target women. I will give certain examples here that some old, some new, and you can see for yourself that what I have meant to be. When partition of India did happen, it was done by, the politicians who happened to be men. And then who were the worst sufferer of this partition? You all know what has happened to women there. So they were the one who were subjected to all this torture because they were treated as an object of honor of the family. So if you are humiliating a woman, you are humiliating the whole community. Again, in Kashmir, we have seen when in 1990, when Kashmiri Pandits were asked to leave the valley, again, you know that this Ralif, Chalif, and Zalif, it was being said. So again, they say, leave your women and, you go from society, from the valley. And, these women should be left to us. Now, this is something that once again is focusing on them. Again, the recent thing that has happened in Iraq through ISIS, when Yazidi women have been subject to the sexual exploitation. Vietnam, when America has attacked Vietnam in the 1950s and 60s, we know that how women have been wronged. Again, in Japan, we know that it has happened. Yugoslavia, we know in the name of ethnic cleansing, the women were subject to all this kind of sexual violations. Again, in African tribes, especially if you have heard about Hutus and Tutsis, you might have seen this once again, this particular ethnic cleansing aspect did come into picture, where women were targeted by the men to humiliate and to subjugate and, we can say settle score with the community of other tribes. As far as the issues law is concerned to deal with such situation, as far as human rights are concerned, we know that certain laws were made in the form of Protection of Human Rights Act 1993. Then, of course, we know that since we have been signatory to CEDAW, as mentioned by Professor Nerela, that Protection of Women from the Domestic Violence Act came into existence in 2005. And then again, this sexual harassment of women at workplace is also an outcome of the this CEDAW, that is the Convention on Elimination of All Forms of Discrimination Against Women. Again, we know that this Criminal Law Amendment Act in 2013, once again after Nirbhaya's case, what has happened, I think it is a very hair-raising rape incident that has happened in India, which was not heard before. And of course, we do not want the repetition of such kind of thing to happen in India. So she was the one who have been subjected to such kind of, ill treatment because she happened to be there at a point of time which will be not a right time for a woman to be out on road in India. So there is something, that is very much speaking in terms of women's position and status, which is time and again proving secondary. meaning she is not being brought into the primary decision-making body, that she can take decision for itself. The decisions are being taken for her. So we can say, as far as the things are concerned, they are very paternalistic in nature. The things are being decided for women by other, meaning we can say that other I see, so I'm talking about man and society, which is primarily having a man's dominating position in it. Then again, some international conventions already Madam has mentioned, like Commission on Status of Women in 1946 came into existence, as you can understand. I think the worst war situation has been experienced by human civilization. And of course, women have suffered like anything. They were the one whose interests were not represented. And when war happens, women are the worst sufferer, as we have heard from the previous speaker. So the status of women was to be, first understood and restored. And again, discrimination, declaration on elimination of discrimination did come into existence. CEDAW came into existence. Then, of course, this declaration on elimination of violence against women came into existence. Then Conference on Human Rights in Vienna, 1995, where for the first time it was said that women's rights are human rights. You all might have been aware of this, that Fourth World Conference on Women in Beijing, when being inaugurated by Hillary Clinton, she was the one who said that women's rights are human rights. So woman has to be first treated as a human, not something about whom others have to speak. She should be treated at par as far as the taking or making choices about herself is concerned. She's not being allowed to make choices about itself or herself. So this is also, one of the a very imbalanced aspect of the society we are discussing about. CEDAW, we have discussed many things about it already. I'll just say for one thing about it, that CEDAW has been treated as a unique convention amongst existing human rights instruments, because it is concerned exclusively with the promoting and protecting women's human rights, and because it operates from the premise that patriarchy is a global reality. Now, this is the point it is focusing on, which I am also pointing out constantly to you, that the patriarchal structure of the society is responsible for lot many offenses which are happening against women. And as you remember, Madam has made a mention of this Vishakha judgment also, or Professor Panda has also made a mention of this Vishakha judgment. We know this CEDAW has come as handy, because we knew that there wasn't any law in India existing about the sexual harassment case when Bhavribai suffered the gang rape as a result of stopping the child marriages in Rajasthan. And we know that at that point of time, there was complete lack of such kind of legislations. So court came stepped into such vacuum, which was existing at that point of time, and came out with the kind of guidelines that, of course, has been a kind of very important legal instrument for us to deal with some situations till we can say 2013, when this act came into existence. So this is, very, very important aspect that we are talking about. And again, I would like to focus certain aspect of CEDAW, what it is trying to tell us. They are saying that it is an obstacle, meaning when we talk in terms of some historical aspect, like they say the General Assembly recognized that violence against women, a manifestation of historically unequal power relations between man and women. It is an obstacle to the achievement of equality and development and peace. For this reason, the declaration provided that states should condemn violence against women and should not invoke any custom, tradition, or religious consideration to avoid their obligation with respect to its elimination. Many a time we all are aware, as I think one of the speaker has also made a mention, India is a diverse country, having diverse cultures here, and women are being subject to different practices. They have different kind of social norms that, or religious norms that they have to follow as per the religion they might be, belonging to, or they might be believing into. So that's why we can see that many a time these issues also do create a kind of hindrance as far as women's position is concerned and speaking for themselves is concerned. So when we are trying to discover, certain points that why this situation is like this, why is it happening as far as women are concerned, why they are being subject to such kind of offenses, which are being, spoken from centuries. I will not say when Professor Panda said that from 1980s, this rape thing has been actually into the forefront, meaning for the first time, Indian society felt scandalized or felt the need to address this particular issue in the manner they did. So this was meaning it was considered as a heinous crime against a woman's dignity. So meaning it was not that rape were not happening prior to that, but then this was a kind of waking up call. People got awakened by the miseries and of course the torture a woman goes through when such kind of things do happen. We know that all these things are rooted in the history and in the cultures. Now I can make a reference of ancient societies like Greeks, Romans, Arabs, Indians, Russians, Europeans, which are consisted of English, French, Germans, and etc. etc. They are all having a different kind of understanding about women's status in their society. We know that many a time when we make a reference of a woman's position in society, even when Article 14, which has been made a reference, by Professor Panda, has taken a leaf from Aristotelian philosophy. Aristotle was not a big champion of women's rights. According to him, male is active, formative principle. The female is clay waiting to be formed. So you can understand what it means. But then his teacher was not actually the having same kind of thinking. He says that no, women are very much subject to a kind of we can say respect to be given, and universal and compulsory education must be given to them. They should also be empowered by such kind of expositions and exposures that we are talking about. So that's why I said that generally all these issues are important and role of society is very important. Whether a woman has been treated as a person of its own or woman has been treated as an object about whom the decisions have to be made. So this is one has to understand that what kind of society we have created for ourselves. We do have a lot of things that we try to understand because as we say about this rape which is happening time and again, and you may hear that media is also playing a lot of role as far as the talking about and condemning about rape is concerned. I will just make an observation here about the number is increasing. Many a time even I used to think that perhaps the number is increasing. It may be possible that number might be increasing because the social mobility of women has increased. Previously, women were confined to their private spheres. Now, what is happening? Women are allowed to come out. And we know that there will be a kind of resentment among men who was till this moment dominating and controlling the social milieu. Now, the man has to share this social space with women now. So there it will be a resentment. Many a time, this was also said that why this hostility in men towards women. It is said that, of course, when women are allowed to move into public sphere, they are taking certain jobs of men also. So that's why this hostility is coming into picture. So this is not the society that we were thinking about. This society is not based on complementarity. We are not saying that this is a society where we say that they both are two wheels of one chariot. It is something that is based on a kind of suspicion in the minds of one towards another. We are not comfortable, as far as others' existence is concerned. We are looking with a lot of suspicion as far as the existence of other is concerned, the presence of other is concerned. We have number of types of crimes that when we talk about that women are being subject to, especially I'll choose the sexual one that I am being asked to speak upon. Rape, the earlier speakers have spoken about, though I can tell you that rape of course has part of number of crimes like ethnic cleansing, genocide, rape itself to settle the score with another community or family, or with a woman itself. We know that that a woman, if she is saying no, then of course she can also be subject to rape and all that. Marital rape is also one that is being brought, that the marriage which is a relationship to be based on the equality and equal understanding, once again we are realizing is having a lopsided imbalance relationship. Here it is being said that the spouse has to say has no right to say no, as far as the sexual intercourse is concerned. So spouse no does not mean a no. So this is not correct. And of course, nobody can claim one's own marital right by raping one's wife. So this is something. And then once again, if we go by the jurisprudential aspect, we can say that it's rooted in the understanding that woman is the subordinate and man is the dominating factor and element in society. Molestation is one. You might be hearing number of cases where girls are committing suicide after being molested. Now, this molestation is subject, which they are being subjected to, is not only confined to the public sphere, it is also present in the private sphere. Meaning, we do hold family as a very valuable and important aspect of our life. We say that family is important to provide us emotional, physical, financial, all kind of security. But many a time we have come to this realization that family itself has become a perpetrator. A family itself has become a reason. Why? So this is something, a kind of sign of a perversion that one has to see to that women are being subject to. And they are not being allowed to speak up. They are being said that if they speak, it will dishonor the family. So as I told you that they have been treated as the bearer of the honor of the family, so they are being subject to lot many violent actions and activities on part of family, society, and community. Harassment is once again, sexual harassment we know is something that is part of the criminal jurisprudence. We know that Criminal Law Amendment Act has made a lot of amendment as far as this part is concerned. And we know the harassment at workplace and of course harassment at the educational institutions, harassment at various places, public places, even the cyberspace, all this is happening. So these are, certain things. And of course, trafficking, which is, as far as women are concerned, they are being trafficked for the purpose of sexual, sexual pleasure, sexual exploitation. For they use the term prostitution. So for the purpose of that, women are being kidnapped, abducted, and all those kind of things are happening. So we know that they are not being treated as a part of the society, as the first category citizen, as we are talking about. So as I say that, they are, and of course, Madam has already spoken about the genital mutilation. So I'm not going to cover that particular thing. But as far as child marriage is concerned, I'll bring you once again to the domain that where a young girl is being married to a sheikh, to the Gulf countries, because these women who are belonging, young girls who are belonging to poor family, many a time, the family is, selling them to the people in Gulf and all that. Meaning you can understand that trafficking, human trafficking, is the largest trade after the narcotics and the we can say weapons. So human trafficking is a very very big organized crime in that, and especially women for the purpose of sexual exploitation have been abducted and sold. So this is something when we try to understand, as far as the women, their position in society and the society's response and understanding of a woman's status in society is concerned. I'll make an observation of a former Justice M.N. Venkatachalaya here, who has, when he was the chairperson of National Human Rights Commission, he made an observation that I would like to share with you, which is of course part of your theme that you are sharing with us today. And that is, the crimes against women were the worst form of human rights violation, needing a socially supported strategy against it. Now, when the speakers are speaking about the prevention part, the deterrence part, and the contribution and role of society, perhaps we can say that stringent laws, strict punishments, all these things are in place. But still, as Professor Panda said, that things are not, abating. So it means that the perpetrators are not scared. Why? They are not scared because we know the whole aspect of the criminal justice administration system. First, the lodging of the complaint that the woman has to go through. Then once again, the next stages when she has to face the court, And then, of course, the prolonged process, you remember Nirbhaya case, what has happened. The thing is started in 2012 and ended in 2019. And it happened in such a manner when the case has or rather aroused the, spirit of the Indian nation, that everybody was so disgusted about the whole thing. And the whole country was very agitated and unhappy about the whole thing. They did not want to accept such kind of thing will be existing in society. And if they have happened, we should try to get rid them with them as fast as possible. So this, despite that, that process took 7 years, and you know that how much efforts have been put in by a number of people to let it happen the way it has happened, because the hearings were not happening, and then dates after date, then the age, and then all kind of legal procedures which will giving lot of respite and gaps, and of course we can say remedies which will given to the perpetrator. They were making availability of all that one by one. So we have seen that how they have prolonged the whole process. In this case, because the young girl died, but the mother and father has suffered like anything. So that's why we are saying that what is the level of understanding as far as these crimes are concerned, and the treatment of these crimes are concerned. So this is something when we speak in terms of these aspects, the women actually feel very uncomfortable to come forward. We know what do happen when these crimes do happen. Then women are the one who are not very comfortable as far as these issues are concerned. They say that speak up, if you have gone through such kind of experiences, don't remain silent. This is what is being followed these days. Now what has happened now, something, because we say the sexual offenses when they are happening, because it damages a woman like anything. Psychologically it damages, socially it damages, professionally it damages, health-wise it damages, meaning a complete destruction of a woman happens when a sexual crime happens. Secondly, she loses on the family front also, because family is also scared of society. They say what people will say, if this thing goes out in public, then what people will say. So that's why they will not speak, for that particular victim. In fact, they will ask that victim to keep quiet, which is not correct. It means, once again, we are saying that society also needs treatment, meaning society is also sick. It needs a kind of treatment where it allows women to speak up, that they have been aggrieved and they have been, they are suffering because of this. Instead of asking to be silent, because I think I would like to say something about a reference Professor Panda made in the beginning about the Hathras case. See, we are not clear whether it was a rape or it was an honor killing, because we have come to know that the woman was having a love affair with the boy of another community. So we do not know what is actually the reality. So we should also try to see from these 2 points that what is happening, meaning the woman has not been treated as a human being, as an individual, as a person who is entitled to all kind of rights, all kind of dignity. She has been just been object, as I told you, of keeping the family honor intact. So first we have to recognize her as a person. She is not being treated as a person, she is being treated as a thing. Okay, so she's not a thing, she is a living person. She also had the flesh and blood. So please respect her like that, and respect her individuality. If she wants to make a choice, allow her to make a choice. Don't impose your choices on her. So that's why a lot of things are happening, when they are trying to bully the girl, to go take a particular kind of decision in a particular direction. Meaning when marriage happens in India, you just see how does it happen. A woman has to be concerned about her, looks also. The looks do matter. The woman does not matter. The dowry do matter, because she is the secondary one. If the father is not in the position to give dowry, what is the status of a woman? Nothing. She is nothing. So that's why if a father has a bulky bank account, then she is somebody to be reckoned with. So all this, and of course, as a result of which female feticide is happening in India. So all this is something And feticide is meaning people are becoming so heartless and so insensitive that they are throwing a baby girl, infant girl, into the garbage, meaning they are not having a human feeling. So what we are talking about, in which age and era are we living into? When people have become so insensitive like metal. I think when we say materialism, I think materialism at its best in this 21st century, where people have got the secondary status, and I think human being, and the material, meaning whosoever is having what kind of economic status in the society has become more important than the person itself. So these are the things when we talk about. I think there is a lot of volumes one can speak about, lot one can speak about, because now I think women has also felt frustrated. That's why they came out with this Me Too sort of program on social media, because we knew that when sexual offenses do happen. See, once again, there is another thing I would like to draw your attention to, the stereotypical, that when sexual offenses has to be tried, keep the identity of the woman secret. Why? Because it will bring a stigma, okay, to her. So why a woman who has been a victim should not speak up? That, see, come on, I have been wronged. Why she cannot say it loudly? Give me justice. Why the society cannot be based on justice and she can shout it louder in a louder manner? If she's speaking, people are very unhappy. So that's why we are saying this. The women has taken to the social media. They are speaking about Me Too. Then they are saying that, of course, they have every right to speak up, but it's still, since I've been part of a particular high-profile, committee in which some international women are also, giving their testimonies, still they are asking me not to disclose their names. So you can see the kind of fear, the apprehension of, facing consequences. So, meaning, what kind of society have we created that could not give a woman to give the woman the confidence to speak up? That if she has been wronged, she cannot speak up. That yes, I have been wronged. So, I think we have to work upon these aspects where woman who has been wronged should not be, looked with suspicion. She should be actually considered as a victim. She should be given the respect and she should be given justice that is actually expected from the society, because she is another component of the society. Without her, there is no society. So since society is consisted of a man, woman, and of course everyone who happens to be a human, so I think this is all I would like to perhaps share here, because I know that sexual offenses have been a kind of instrument, a tool in the hand of a man to show that I have more brute force than you. And that's why I quoted Gandhi in the beginning, who said that this is not a society that we are thinking about. This is something, very animalistic, based on a kind of barbaric society, not the civilized society. So if we talk about the civilized society, let's, allow women to come forward. And I say that even it should not happen. They should not be actually treated as an object who can be, inflicted injuries, who can be harmed, who can be injured, and who can be an object of, we can say, sexual pleasure. She should not be treated like that. She should be treated as a person who is a living person, who can feel, who can love, who can care, who can, do all kind of things which she's also capable, as a man could be far more capable than man could be in certain aspects. So with these words, I would like to end my presentation today. Uh, though there is, a lot to say, because this is a kind of topic, everybody would like to share their views and discussion. So I would like to end my, thing here. Thank you very much for giving me your attention. Thank you so much.
Thank you, ma'am, for putting across a simplistic yet enlightened side. Thank you, ma'am, for addressing a very mundane question of why women rights are mostly talked of. Your words have added many credentials to our knowledge. I thank all the three prominent guests for putting across their take on crime against women and human rights, problems, and perspective. We all participants are grateful to hear you all. Now I welcome Preeti to take ahead the questions to our guest, thereby making the session more efficient.
Good morning, everyone. Am I audible?
Yes, Kriti, go ahead.
Um, yeah, it is Aditya. I'm here to present the questions that are given in the chat box. So question number 1. What can we do as an institute to avoid any violence or crime against women? What mechanisms can we include to ensure a safe environment for everyone? Ma'am, may I repeat the question?
Now it has to be very specific who has to answer, anyone can answer, or who has to answer.
Ma'am, anyone can take up the question, ma'am.
So
think
Madam
the
Nirala would like
question-
to see, or Madam Rajni would like to speak, or
I think the
What is the
question has been
question?
asked
Can you
to,
please repeat the question? It was not little clear.
it is in the chat box actually, huh?
I think this question has been given to all the, just to all the panelists, any one of the panelists probably. I think the question again is, if I read it correctly, what can you do as an institute to avoid any violence or crime against women? This is the question. This is the $1 billion question. The government of India as an institute, the government of India as a nation, the governor of criminal justice administration as the institute. I've been struggling for this particular question. If we have a clear-cut answer, this is how we can really solve the problem. Probably it's a magic wand. We have done it. It's a social problem. The crime is so deep-rooted. That is the frustration I expressed at the beginning of my lecture. In the very beginning, when I started while introducing the topic, this is Professor Panda who is speaking. Please note down. This is what we have expressed very categorically. If we would have known any particular answer, what exactly we're doing at the age and date is we are creating a situation where the people will be serious and concerned and they'll be sensitive to the issues. We conduct seminars, conferences, symposiums, and we try to bring the people to think seriously about this type of problems and see how the problems can be avoided. This is what we have been doing in a sensitization exercise. But I'm not sure this is really creating a situation, new environment where this against women totally can be abated, totally stopped. And there's no mechanism as such. Yes, mechanism if that particular animal inside everybody, which really works out to be the criminal, and the criminal who really hops into a isolated or a woman and create this particular problem can be killed. This animal is there in everyone. This animal has to be totally killed. Where is that particular situation? What is that particular situation? As Justice Rajini has told, the probably situation is we have to create such a socio-economic environment, a sociological condition. I don't know how we are going to create this situation. There's no easy answer for this type of question. Only thing is we have to sensitize ourselves. And how to sensitization? Justice Krishna has gone to the extent of saying transcendental meditation. If I do long term back. And now the question is, somebody may say meditation, somebody may say realization, somebody may say right education, somebody say culturalization. Whatever your movies that they are doing, what the Bollywood is doing, what is the Hollywood doing, what is your new type of environment, liberties, these wonderful gadgets, what they are doing. Are they really creating an environment where you'll be cut off? Now you're open for every type of information available in the world, which is meant for you, which is not meant for you. And now it is for you to take a choice how much you to grow the animal inside you and how to tame the animal inside you. If you're able to tame the animal inside you, the society is wonderful. If the animal inside you lets loose, you are responsible. That's all. That is it, my answer for the first question. If anybody wants to add anything, they are free.
I think you are very rightly said, but the only thing is that whatever as a law student we all are learning is the mutuality, that we have to respect each other. If we do not know all that, the basic thing which is required for a kind of civilized world that we are constantly talking about, and that is why the whole thing is coming into place. It is important, actually, we should start doing that, because it may sound simple, but it is very difficult to practice. That's everybody has to respect everyone's sphere, domain, and all that. Don't make a kind of imposition on other. This is a very difficult, as I say, saying is easier than done. So that's why one has to, because Professor Panda has rightly said, all these efforts are to make you understand that what are the roots, and how far we have traveled, and how can we correct all those things. So thinking is that women should be, of course, treated as an individual. Their no should also be treated as a no. And yes, of course, as far as modern society is concerned, as I said in my presentation, that power is the one. Whosoever is the power wielder, whosoever is having power, is becoming the abuser of that power. Generally, we have seen the tendency of misuse and abuse. So one has to desist from it, because it is a more of responsibility, than abusing others. So that's why, and the onus is on the person itself. You correct yourself, and then the correction will come from others as well. So this is quite an important part, and of course one has to take care of that.
Since I also should say something, otherwise, I think that I'm missing my part. So while agreeing both and Professor De Prasad, actually it's social issue, as he very correctly said, that everyone has an animal as well as a saint. You call your saint rather than the animal or the devil. That is one thing. Now she asked that, what the institutions like can do that to prevent. Actually, it is, prevention, crime prevention is a little bit of a different thing than, when we fix a person and, start the criminal justice process. It is more towards that, the social, the development. So everybody are human beings. Therefore, unless you correct and you prevent and you consider that all the other members in the society is, similar to you. This is what Lord Buddha and even the Hinduism, every the religion say that, you consider the others are similar to you. So then if anybody pinches you, it is, you get pain. Therefore, consider the other people as well. So if each and every person in that way, since it's a very, the crime is a social phenomenon. Therefore, so then we can prevent, at least to some extent. So once it is done, as said, when your animal is waken up, so then the law is there. Then we have to have a strong law. For what? Actually, to bring the person to the court and provide the justice. Sometimes when we consider the real reasons for committing this type of things, sometimes the perpetrator, the particular given time, so he was the victim of another previous time. So it sometimes led you to commit that type of crime. So therefore, and the punishment as well as the rehabilitation also, it is really necessary when it comes to, prevention for the reconviction or the recidivism rate, especially in relation to not only for crime against women, to anybody. Therefore, the prevention part is a social and the legal, the two aspects, come together and to support people. So therefore, one particular, the very hard and fast mechanism or the answer is not there, but it is, taking everything together and consider. But finally, I want to say that yes, try as much as possible, control yourself, try to correct yourself. Then I think half of the problem can be solved. Isn't it, Professor? Yeah. I think that is one of the institution can do that. Yes, we all. Thank you.
Second question. When the educated and people in position of power are resorting to victim blaming and trying to find ways to brush everything under the carpet, how are we really expected to make progress?
To me, actually, it is an extension of the same problem, right? So then the victim blaming, it is once again the issue of the society. because everything, I think social attitude is like that. If something goes wrong, mother is the most responsible person. If it is get corrected, if it all, the police and everything, yes, the father and everybody are trying to, get the credit out of that. Yes. But, if something happen and if something goes wrong, the woman is that. Therefore, the attitudinal change is really important. But see that, I don't know, I really want to ask you the question. If something happened to one of your friends or to you, let's say that the sexual kind of harassment or the issue, that whether, how would you deal with that? If that's something that happened to the friend, how would you do that? And whether sometimes I ask the same question from me, if I would like to take, as my daughter-in-law, right? Those who have, faced for this type of issue, that is the issue. I mean, this is what we want to ask the question from ourselves. Therefore, this is the attitude. Sometimes we are talking about the discrimination of women, but I think women are also part of that. Women are actually, we are discriminating the women who are really subjected to specifically the sexual violence or the crimes. Therefore, I think it is to me, the attitudinal change should be there. It should be begun from your home. The mothers are responsible for, to teach all the sons and daughters equally, not the good and the big thing for the son. I mean, the small and the left out things for daughter. So then we have to consider that aspect also. Then at least, this has been, grown to finally to the extent, commit crimes, and it goes to the society, because smallest unit of the society is the family. So then family also has the responsibility to come for this, the attitudinal change. So my simple answer is that. But we can write, thousands of papers, right?
What I think, as far as my opinion is concerned, in addition to that, what Madam has said, is that, see, the whole thing is a constant process. What do we think that we just try to, have as a one-time thing? Like if we talk about the institution, we know that law is an instrument which makes provision for certain mechanisms to be, adopted by the institution. Now, working and functioning of these institutions is responsibility of everyone. It's not, that only those who are the office bearer, this is their responsibility. No, it's responsibility of those who are also watchdogs. Because as far as when we say who will guard the guardian's philosophy, so it is very important that people do forget about their roles. What do I realize generally in the whole setup? That people do depend too much on the institutions and formal mechanisms. They forget one part about this, that formal mechanism will be effective only when we are being a watchdog, we are asking questions, when we are examining, scrutinizing their performances, and we are making them work. If we are not doing that, we are not playing our role, we cannot just raise questions, that, what you are doing, what can be done. Because first of all, one has to come forward, then has to do the follow up. Or if the one is not the victim, has to stand by the victim, or whosoever the person is, one has to stand by. And as I told you, it takes a lot of time and all those kind of things. So try to help the administration in resolving those issues. If administration is not resolving, ask questions. This is what is the beauty of the democracy, that you raise questions, you ask questions, that what is being done. Because we know that such kind of things, Sexual Harassment Act has said this is time bound. So you have to actually be answerable. When the complaint comes, you are answerable in 90 days. You must ask. If 90 days has lapsed and things not as have moved, ask the question. Then have guts, have courage. What is happening, what I have realized by more from my own experience, because what I'm going through currently, and this is general practice, that we do want to have, the advantages in both the hands. We don't want to, have the face repercussions that will come our way, because we know the systems are like that, because we are allowing them to be like that. So I think stand up and challenge the system also if they are victimizing you. If the system itself is victimizing you, just stand up against the system. Try to make the changes in those systems which are victimizing you, and try to eliminate those factors which are, making them, or making, a particular provision for the exploitation. So this is what the whole process, I say, constant process, and active participation is an important aspect to keep a track, keep a check, and of course to make the system work. Merely making observations and criticizing and doing will not help. See, this Sexual Harassment Act, now we are in 2020. 2013 it already came into existence, and a lot many organizations are not even having internal complaints committee in place. So is there anybody who is asking question? Is the government slapping fines against them? Is government, withdrawing their recognition? Is any lawyer doing that? So nobody is doing that. Are we bothered about that? And what is actually happening to this law? Are we making an impact assessment of any law, that when such kind of laws did come into place, what is the performance of such law? Is it actually being effective or not? So all these are interconnected. These are not isolated questions that one has to treat separately. So the instrument that has come into picture to give the remedy, whether this instrument in itself proving to be effective or not, how many of you actually try to test that? Nobody, na? And once again, I think one question I could see, the man and woman. Yes, of course. See, law is there for everyone's protection. It is not for, because Criminal Law Amendment Act has actually given a definition of rape which is gender neutral, one. And now I think another bill that has been brought to the parliament is about the gender neutrality of all these kind of things that they are talking about. Otherwise, criminal law is very much there, that the assault, the criminal assault in itself is generally has been a subject of, punishment, or we can say whatever the, criminal law justice can be done to that. So I think this is my point on that, what I wanted to say.
And I want to add little bit. As very correctly you said, Professor Raka, the people, they are passive observers. When it comes to, the very particular time, because I am now handling a lot of sexual harassment cases in the university system, many professors and students, maybe postgraduate or undergraduate. The only thing is we don't have that enough evidence to prove, but it actually really happened. But the students, they are reluctant to come forward to give answer and all, evidence and all. Therefore, yes, that is, of course, you have to have, rather than mere passive observers, you have to take part in active participants in the justice process. So then it is one, and if really want this, the students, you can have some sort of workshops and other things, awareness programs like this, the enlightenment programs to make you understand that, what are the laws and things like that. So, but you have to have the courage then, to come forward if something goes wrong and to correct that, because that is all our right as the human beings. Thank you.
Last question. Sexual harassment is faced by both men and women. Do you think men are given equal treatment as women in sexual harassment cases?
To me, actually, if you go through the sexual harassment, we don't have the Sexual Harassment Act in Sri Lanka. We have only the simple section which is incorporated into 1995. It considers irrespective of the gender, it is, everyone can be, anybody can be a perpetrator and anybody can be the victim. So it considers the trauma, also the emotional, the harm that the person had undergone. They are actually, unless that you have, take, the amount of trauma, the seriousness of trauma. So in actually, you can't say that how you have to. And when it comes to some, it based on the tolerance. Sometimes, the men can be totally, exhausted and collapse than a woman, because to a woman sometimes has all the courageous to, tolerate everything and come up, as a very silent sufferer. We call most of the time women are silent sufferers. But when it comes to Sri Lanka, there is no such, to see that whether who has, to undergo it. It depends on the situation, the seriousness of the people, the person's ability to tolerate, and so on and so forth. But it is, other than the physical injury, the harassment may be the assault, that may be the physical, it may be the sexual, emotional kind of thing. So when it comes to especially the physical, the harassment, you can see that violence. But when it's especially when it comes to the emotional, harassment, that emotional harm, the psychological harm that the person has undergone, the victim. So then, to me, I don't know, difficult to me to say that, who has the capacity to tolerate that. But so far, the experience that I had, I never come across that. I handle many sexual harassment cases in the university system, being as the chairman of the formal inquiry, the committees. So male people are the accused rather than female. Female were the victims. So some, I don't know whether they are tolerate or tolerance or the stigma, they do not want to come up. It goes to the dark figure of crime rather than. So then the tolerance, it actually, to me, based on the situation, based on the person's capacity, the tolerance and all. So then other than physical, it is, if the harm is visible, yes, of course, you can say that. So, but especially when it comes to the emotional, you can't. Sometimes men are collapsed before female. Yes, interesting questions. Box, there is a question, no?
Yes.
There are some.
Ma'am, the other questions are similar to the questions which are asked, except there's this question to all panelists that as an educational institute, how do you suggest harassment cases in COVID situation?
COVID situation, is there a possibility? Meaning,
Yes.
The question was not, it was not clear to me when you were talking. There was an interruption. Possible, can you please repeat?
Sure, ma'am. Ma'am, the question is, as an educational institution, how do you suggest that an institution should proceed with sexual harassment cases in the midst of COVID situation?
I would like to give only my experience, right? So then actually we are having a sexual harassment case. Now we are, handling that. So then actually the question arises was whether to, call under the Victim Protection Act in Sri Lanka number 4 of 2015. It is, the audio and video, the pre-recorded, the visual, and the audio, the evidence can be supported. But some of the, therefore now, since because of the COVID, if they are unable to come in order to, just to expedite the process rather than, dragging. So one possibility is to given the opportunity or the chance to the victims or even the perpetrator to give the evidence, from using the modern technology. But when it comes to the cross-examination, right, in the disciplinary inquiry, this is bit of a problem. So then we were actually, I don't know whether it is a coincidence, when we had the issue, the last meeting to, proceed with this, the latest case, it was the issue considered that, how we can do the cross-examination because, within 2-3 days, there were 6 the witnesses. So then some of the parents, they don't like to send their children from far away. These universities, I don't want to name the university, the Colombo. So then the issue arose whether we have to go to them or we call them. Then I said that even being as adults, but if we provided all the the precautions, so then we can do. But so then there is no any policy we have taken so far to consider in this type of situation how we can proceed with that. It is one of the problems. But as a remedial measure for this particular case, we decided to call them and make them to utilize the modern technology. But issue is the cross-examination and the re-examination. So then we have to, consider that to have a brainstorm and to create how we can do that, because once it is done, it would be, considered as a precedent. Therefore, we have to, consider, for the long run, whether we can have this practice. And we don't know because of the COVID. We don't know now. The entire things are uncertain. We don't know what would happen. So therefore, we decided to come with a policy with regard to the examination in chief, then the cross-examination and the re-examination, even in this disciplinary inquiry process, how we can learn technology to provide the justice. And the other thing, I think India also sometimes they have this issue, the language issue. We have that, the different languages and all. So then the expressions also, it gives some sort of, the idea what they have really done and all. So therefore, however, we have to, get the support of the modern technology. That is my simple answer for that, in my experience.
Yeah, that is the same in India also. We also take the help from the technology and all that.
Yeah.
So the same issues here. There is no other option but depend upon
Yeah.
technology and all that,
Yes, yes.
as we are doing now.
Yes. All right. Thank you so much, all the guests and participants, to put your valuable questions. Now I welcome our registrar, sir, Professor Dr. K. Rao, for his concluding remarks and vote of thanks on behalf of Universe.
Good afternoon to everyone. So on behalf of the DSNU family, I express my sincere gratitude to Honorable Chief Guest, Justice T. Rajini, for sharing her thoughts on the theme of today's national webinar. And I would like also thank the guest of honors, Professor Muthukuda Neralla, Professor of Public Law and International Law from Colombo University, Professor Raka Arya from National Institute of University Bhopal, and Professor Surya Prakash for inaugural address, Professor Bhavani Prasad Panda, academic advisor, for making the beginning of this particular theme. And I also thank Professor Rajendra Prasad, Professor Dayananda Murthy, and all my colleagues who joined here for this particular webinar. So this can't be happened only because of this particular Gender Champions Committee headed by Nirmala Madam and Bhagyalakshmi Madam and student activists. So I would like to also thank Harika Rajapurohit and also the question anchor Shruti for a wonderful webinar on this particular day. Thank you one and all for this particular opportunity for us. Thank you one and all again.
Thank you very much.
Thank you very much. Thank you.
Thank you, Madam
Namaste,
Naren. Thank you.
everyone. Okay.
Thank you, madam.
Thank you, Professor Surya Prakash.
Okay, right. Thank you, Bhagyalakshmi.
Thank you, sir. Thank you very much, sir.
Nirmala Madam also. Wonderful.
Thank you, sir.
Thank you, sir.
Have a nice day to everyone. Thank you.
Okay, ma'am.
Thank you.
Thank you all.